A software engineer in Texas lost her job on a Tuesday, not because of poor performance, not because of layoffs. Her employer looked at her Employment Authorization Document, saw an expiration date that had passed, and told her she could not work anymore. What her employer did not know, what nobody told them, is that she had filed her renewal 4 months early. Her work authorization was legally valid, completely valid. Under a federal rule her HR department had never heard of. She lost 3 weeks of income and nearly lost her job permanently over a rule that USCIS published but never made sure employers understood. That woman is not an edge case. In 2026, she is one of hundreds of thousands of people trapped inside an EAD delay crisis that is destroying livelihoods, derailing careers, and threatening immigration stability for people who did absolutely everything right. Today on Global Immigration News, we go inside exactly what is happening, exactly what your rights are, and exactly what you need to do right now before your situation becomes her situation. Welcome. Let us start with the number that defines this crisis. USCIS is currently processing Employment Authorization Document renewals at timelines that in many cases are running double, and in some documented cases triple, the estimates published on the agency's own website. Applications filed 6 months before expiration are reaching their expiration date with 0 adjudication and 0 communication. And the people holding those applications are waking up every morning to the same case status message they saw the week before. Initial review. That is it. No movement, no explanation, no timeline, just silence, while the date printed on their EAD card gets closer and closer to the number that will change everything about their daily life. Before we go deeper, and we are going deep today, because the details in this situation are where the protection lives, you need to understand what an EAD actually is and why its processing failure hits differently than other immigration delays. An Employment Authorization Document is not a visa, it is not a green card. It is a standalone work authorization document that certain non-citizens must hold and maintain separately from whatever underlying immigration status they have. And for the people who depend on it, there is no backup, there is no alternative authorization they can fall back on. When the EAD expires, when that date passes, the legal right to work in the United States expires with it. That is the stakes, not inconvenience, not paperwork, the legal right to earn income and support a family. Now, who is inside this crisis in 2026? Because the EAD covers a wide range of applicant categories and the risk profile is different for each one. Adjustment of status applicants, people with pending I-485 green card applications, are one of the largest affected populations. These are people who filed for their green card years ago, who are waiting in a queue that moves in months and years, and who are renewing their EAD for the 2nd or 3rd or 4th time while that process plays out. For them, a renewal delay is not a new problem. It is a recurring threat that has gotten dramatically worse in 2026. H-4 EAD holders, spouses of H-1B visa holders, represent another major affected group, and their situation carries a particular cruelty. These are educated professionals, many of them with advanced degrees and years of work experience in their home countries, who were authorized to work in the United States under the H-4 EAD program. They built careers here, they took jobs, built client relationships, contributed to their households and their teams. And in 2026, processing delays are forcing many of them to stop working, not because their authorization was denied, not because anything in their case changed, simply because the renewal is sitting in a queue that is not moving fast enough. DACA recipients face EAD delays with consequences that go beyond employment. For DACA holders, the EAD is not just a work document. It is the document tied to their protection from removal. A gap in DACA EAD validity is a status problem, with immigration consequences that are immediate and serious. Nearly 600,000 people live with this reality, and in 2026, the processing times in this category are a documented source of crisis for people whose entire life in the United States depends on a renewal that USCIS is taking too long to process. TPS holders, pending asylum applicants, and applicants in various other authorized categories round out the population living inside this crisis. The common thread across all of them is this: they filed correctly, they filed on time, and the system is failing them. Now we need to talk about the automatic extension, because this is the rule that could protect your job right now, that most applicants do not know exists, and that most employers do not know they are legally required to honor. Here is how it works. For certain EAD categories, when you file a renewal application before your current EAD expires, federal law automatically extends your work authorization past the expiration date printed on your card. You read that correctly. The date on your card can pass. The card can look expired to anyone who reads it, and your work authorization can still be fully valid under federal law, because a timely filed renewal triggers an automatic continuation of that authorization while USCIS processes your application. This automatic extension currently runs for a significant period for eligible categories. USCIS has extended the protection period multiple times in direct response to the processing backlog, and the current applicable period for your specific category must be verified against the most recent USCIS guidance because it has changed before and can change again. What does not change is the principle. If you filed your renewal before your card expired and your category is eligible, your work authorization did not end when the date on your card passed. So why are people losing their jobs? Why is the Texas engineer's story not a rare exception? Why is it happening hundreds of times every week across this country? Because employers do not know this rule exists. Human resources departments look at an expired date on a physical card and apply the most straightforward interpretation. Expired means expired. They have not read the USCIS employer guidance on automatic extensions. Their legal teams have not briefed them on it. And in the absence of that knowledge, they make a decision that feels legally safe to them. Stop the employee's work authorization, while actually violating the employee's federal rights under a rule the government created specifically for this situation. This is the knowledge gap that is costing people their jobs in 2026, and you need to close that gap, not for your employer, but for yourself, before you need it. Here is exactly what you need to have in your possession, and exactly what those documents prove. Your expired EAD card, combined with the I-797 Notice of Action receipt notice from your pending renewal application, together establish your automatic extension eligibility. The expired card proves your category. The receipt notice proves your renewal was filed before expiration and is currently pending. Together, they create the legal documentation for continued I-9 compliance. Your employer should record both documents in your I-9 employment verification file, not the card alone, not the receipt alone, both together. That combination is the automatic extension documentation package. If your employer's HR department looks at your expired card and says you need to stop working, do not simply accept that. Walk to HR the same day with the USCIS published guidance on automatic extensions. It is on the USCIS website. It is public. It is written specifically for employers. Print it. Hand it to them. Follow up in writing, email, so there is a documented record of the communication. Most HR compliance situations resolve at this level when the correct federal guidance is placed directly in front of the decision maker. They are not trying to harm you. They simply do not know a rule exists that changes everything about what your expired-looking card actually means. If providing USCIS guidance directly to HR does not resolve the situation, if you are told that their legal team has reviewed it and they will not accept your automatic extension documentation, that is the point where immigration legal counsel becomes not optional but essential. An attorney's communication to your employer's legal department carries authority that a conversation between you and HR cannot replicate. And in 2026, immigration attorneys who work with employment-based clients are handling exactly these situations on a regular basis. Now let us talk about why the delays are this bad in 2026 specifically, because understanding the cause tells you something important about how long this situation is likely to persist. The EAD processing crisis did not appear overnight. It is the product of compounding factors that have been building for several years and reached a critical mass in 2025 and 2026. USCIS entered this period carrying a structural application backlog built over years of underfunding, staffing gaps, and a technology infrastructure that independent analysis has consistently described as inadequate for current application volume. On top of that existing weight, policy changes implemented in late 2024 added new review requirements to certain EAD categories. Those new review steps require additional processing time. The staffing levels at USCIS service centers were not increased to absorb them. The result, a system that was already running behind, began running significantly further behind in categories where the consequences of falling behind are direct and immediate for the people living through it. The published processing time estimates did not update in real time to reflect these new pressures. They continued showing historical averages calculated before the policy changes took effect. Applicants who planned their renewal filings based on those estimates found that the timeline they built their planning around was no longer accurate, and by the time they discovered that, their expiration dates were already close or already past. What can you actually do right now? Let us be direct, because general awareness is only valuable when it produces specific action. First, if your EAD expiration is within the next 6 months, file your renewal today. USCIS has extended the early filing window for certain categories in response to the backlog. Check the current early filing rule for your specific category and file at the earliest authorized date. Every additional day of processing time you give USCIS before your expiration date reduces your risk. Second, file your renewal completely. Every form, every field, every supporting document. Requests for evidence, pause your application and send your response to the back of a processing queue. An RFE caused by a missing document or an incorrectly completed form field can add months to a timeline that is already months too long. The most impactful thing you can do for your specific application is prevent the RFE by filing perfectly the first time. If you are not certain your application is complete and correct, the cost of having an immigration attorney review it before you submit is significantly less than the cost of a 4-month RFE response cycle. Third, track your case status actively. If your application is pending beyond the outside processing time listed for your specific form and category on the USCIS website, submit a service request through the USCIS online portal. This creates a documented record. It does not jump your place in the queue in most cases, but it starts a paper trail that matters if you need to escalate. Fourth, if your situation is urgent, use congressional inquiry. Your U.S. representative and your U.S. senators have casework offices that contact USCIS on behalf of constituents with documented urgent situations. A congressional inquiry does not guarantee action, but it creates a level of attention on your specific case that a service request alone cannot produce. Applicants who have used this tool in genuinely urgent situations have reported resolution timelines that were meaningfully faster than the standard queue. It is a legitimate tool. Use it when the situation calls for it. Fifth, if you have an EAD that was issued on a different category basis than your renewal and you are changing categories, the automatic extension does not apply. Category changes require a completely new application, and the protection of the automatic extension does not carry over. Know your category. Know whether your renewal is same category. This distinction determines whether the automatic extension is available to you at all. Sixth, document everything. Every filing receipt, every service request response, every communication with your employer about your work authorization status, every date. In an immigration system where case history matters and where errors and gaps have long-term consequences, documentation is protection. Maintain a complete organized file of your EAD application history, not just your current application, but every renewal you have ever filed, every receipt, every approval, every correspondence. The EAD delay crisis of 2026 is not a problem that individual action can solve at the systemic level. The backlog is structural. The staffing shortfalls are institutional. The policy changes that added processing load were implemented without commensurate processing capacity increases. These are system-level failures, but what individual action can do, what the right information at the right time can do, is protect you specifically from the worst consequences of a system that is failing the people who depend on it. Subscribe to Global Immigration News right now. EAD processing time changes, automatic extension rule updates, USCIS policy developments. These are exactly the updates that require a consistent, reliable source that covers them when they happen. When USCIS changes the automatic extension period, and it has changed, we cover it the same day. When new guidance drops that affects your rights as an EAD holder, we break it down in language you can use immediately. Follow our WhatsApp channel, link is in the description, for real-time alerts the moment something changes that affects your work authorization. Here is what you must remember. EAD processing times in 2026 are running significantly beyond USCIS published estimates. Plan for longer, not shorter. The automatic extension provides continued work authorization for eligible categories when a timely renewal is filed, but it requires documentation and employer education to apply correctly. Your documentation package is the expired card plus the I-797 receipt notice, both together, not either alone. Not all categories qualify. Verify yours now. File your renewal as early as the rules permit, file it completely, and prevent the RFE that adds months you do not have. If your employer will not accept your automatic extension documentation, escalate in writing with USCIS published employer guidance. Congressional inquiry is a legitimate and effective escalation tool for urgent cases. And document everything. Every receipt, every date, every communication. You did everything right. The system is failing you, but you are not powerless inside it. Stay informed, stay prepared, and we will see you in the next video.